Okay, thanks, Dave. Good morning. This is a convening of the Massachusetts Gaming Commission. As we're holding this meeting virtually, I'll ask for a roll call. Good morning, Commissioner O'Brien.
Good morning, I'm here.
Good morning, Commissioner Hill.
Good morning, I'm here.
Good morning, Commissioner Skinner.
Good morning, I'm here.
And good morning, Commissioner Maynard.
Good morning, I'm here.
All right, we'll get started. This is a continuation or we're resuming our review of the application of FBG Enterprises OpCo LLC, doing business as Fanatics. And I believe this is our fourth meeting with you. And so we, again, extend our great appreciation for your patience as we navigate our busy schedule. We met yesterday at 8 as well, from 8 to 10, and we were able to get through much of the list of items for executive session, but not all of them. Our legal counsel has advised that we can go right into our executive session now because we have a proper vote on record. So with that, to the public, we will.
So, Madam Chair, actually, before we go, there was the one matter that I had raised with them yesterday. There was a discussion of whether they might be able to quickly talk about it now before we move into executive session. I just wanted to see if we still want to do that or wait till we come back out.
And I'll just finish this sentence and then we'll do that and I'll ask if there's anything else.
Okay.
So
Thanks.
we'll be convening back in the public session. This is an opportunity, as Commissioner O'Brien just mentioned, for us to consider whether there's anything else that we would want from an executive session, anything else addressed. And Commissioner O'Brien, I know you raised at least one item yesterday.
Yes, and we may not have to go into executive session for it. It's more the open source check that was done, surfaced some articles in connection with Mr. Rubin. He divested himself of his ownership shares in some professional teams. And then there was some assigning of a Philadelphia 76ers player, James Harden, and whether anyone on the company can speak to sort of what was out in the public ether on that topic.
Sure, Senator Berger. We saw the comments in IAB's preliminary report, which was media speculation. I think the company views that as just unfounded and untrue media conjecture and speculation. That there's nothing to substantiate that. In reality, certainly if IAB is against their final, their future investigation, if they have further questions on the topic or any additional information comes to light that they think is relevant, the company or its principals are more than happy to speak to anything that comes up. But as of now, we think it's just again completely unsubstantiated.
Okay, great. Thank you for addressing that publicly.
Thank you.
Is there any other matter, commissioners, that you would like to raise before we go into executive session? Anything that you think is appropriate for executive session? All right, then we'll have our team offer the opportunity to go back into the virtual room. Thanks so much.
It's just gonna be 1 minute.
No problem, Kristen. Okay, Dave, I think we're all set. Thank you.
All set.
Great, thank you. Okay, this is a reconvening of a public meeting of the Massachusetts Gaming Commission, and because we're holding this meeting virtually, I'll do a roll call again. A second good morning to you, Commissioner O'Brien
Good morning, I'm here.
and Commissioner Hill
I'm here.
and Commissioner Skinner
Good morning.
and Commissioner Maynard.
Good morning, I'm here.
Okay, so we just finished up in our executive session and have addressed all the matters that we anticipated addressing. I think that there's a very brief clarification that we think will be helpful for the public record, appropriately so. And so we'll turn first to Mr. Berger and see if there are any questions from you commissioners on that. Oh, maybe perhaps Mr. Grossman, you'll just remind all of us on the individual topic. Are you all set on that?
Yeah, no, I think Mr. Berger can, or Ms. Nguyen can take it away. It relates to the interest of James Harden and his involvement with the company.
Okay, were we
No,
on?
but not that one.
Or we
No,
can.
the class action.
Yeah, the
Oh, I'm
class.
sorry,
action.
my apologies.
Yeah.
Yes, absolutely. You already talked about, yes, the Sherman Act case that was discussed.
Sure. On those, I think our public statement, we obviously discussed more in executive session, but there's 3 cases that have been publicly filed. All the pleadings in those cases are publicly available. We certainly welcome the commissioners take a look at those. We would say in all 3 cases, defendants have filed pre-motion to dismiss letters, in which Fanatics in each of those has stated the complaint should be dismissed. We would say that those motions speak for themselves in terms of our current defense in those cases.
Any questions on that, commissioners? Commissioner
Not a
O'Brien?
question, so much as just a record clarification. It's also my understanding they were going to just forward to us a copy of the complaint and the motions that were filed, so we have them.
Yeah, we'd be happy to do that. They're all on the public record, but we can certainly forward them to Attorney Grossman.
Great, thank you.
Any other questions he has, and for additional documents, on public record, we can provide as well.
Thank you. Commissioners, at this stage, are there any other questions for the applicant? We do have to take our temperature, and Commissioner Skinner, I know you're not feeling great, so this is not a good choice of words when I say take your temperature today. But if we could find out if we have a consensus with respect to 4 sections of the application, we need to turn back to sections B, C, E, and G. So if you have your notes available, we began that evaluation process yesterday. And we've had a great deal of information through our rigorous discussions in executive session and in the public session. So with respect to section B.
Madam Chair, I would
Yes,
say the applicant has met expectations for section B.
thank you, Commissioner Hill.
I agree.
Thank you.
I agree.
And Commissioner O'Brien, everybody's just to their notes,
yeah.
which is a good thing.
I agree, and I have to say that the executive sessions the last couple of days have helped me tremendously in being able to make my assessments on these. So I would agree they satisfy.
Thank you.
Madam Chair, very much like yesterday when we had another applicant, I think I could streamline this by saying that I believe section C, E, and G have met expectations.
With that, Commissioner Skinner, are you as comfortable with that, because we can break it down?
I am comfortable with that. I also agree that the applicant meets expectations on all of those sections.
Okay, thank you. And Commissioner Maynard, are you comfortable with the collective look?
I am comfortable saying they have met expectations in every one of those categories.
Thank you. And Commissioner O'Brien?
I am. The only caveat is for me on E for responsible gaming. I would have a, if we move on to voting them a license, approval, I would like the condition on confirmation that the anticipated January 25th board vote adopting the responsible gaming plan. That to me is a big part of whether I felt like they satisfied E. And they moved it up. It's my understanding that that's going to happen imminently, but that is sort of critical to me saying yes on E.
Commissioner O'Brien, if I may, I think generally we'd be amenable to that. Can we just have a little bit of flexibility just in case there's a scheduling conflict or something, so it's not on, that exact day, if you will?
Yeah, I think I would condition wording is such that if it doesn't happen on that day, that we get notice prior to that date. My big concern is the idea that it might launch, you might be trying to technically launch prior to having that approved. So maybe that's it, is that the understanding that that's going to be approved at the board level prior to any potential launch in Massachusetts.
I think that's clearly our intent, and that makes sense. We prefer one like that, just, again, in case
rather than a date
or gathered or, something happened that it could happen on that exact day.
Yeah, I think that's the intent of what I'm saying, is that it be approved at the board level prior to any launch in Massachusetts.
Commissioner O'Brien, just to be clear on the record, I believe our application asked for a draft and not for final.
No, I know, but everyone else who's come before us already has an approved one, and then it's sort of how are you going to change it to Massachusetts? They didn't have one even at the corporate level at all. So that's the concern.
I was going to ask if you could make that distinction. So I wanted that to be clear to the applicant. So I guess I really do appreciate the immediate responsiveness in what we saw. And so to Commissioner O'Brien's point, it's because of your new history as opposed to old history. So that's
right.
Okay. And so we'll explore that in further detail down the road. So otherwise, I'm taking your temperature now, Commissioner O'Brien.
Yeah, otherwise satisfied as to C, E, and G.
Yes, and I have to say that I thought this application was excellent, very strong, and very much appreciate from several, now a few weeks ago, not a few weeks, but I think before the holidays, certainly when we had your presentation, all of it put together. It's been very, very helpful, and we appreciate again candor in answering all of our questions. So thank you. But the application for me was a pleasure to read and assess. So so I'm good on all sections. Now we turn to I want to get the agenda out. It's item number 7 on this agenda, where we would turn to whether or not we'd like to proceed with having Mr. Grossman help us go through the determination process. Commissioners, are we at that juncture comfortably? Okay. Mr. Grossman.
Thank you, Madam Chair. At this juncture of the proceedings, we'll turn back to section 218 of the regulations, and you'll recall specifically 218.06 sub 5 sets out the standard under which the commission will determine whether to award a license or not, and lays out all the factors and sub-factors. So I'll walk through those right now. And ultimately, the question will become, do you find substantial evidence in the record that the award of a license to this applicant would benefit the Commonwealth? Just by way of refresher, when we say substantial evidence, the term itself is defined as such evidence as a reasonable mind might accept as adequate to support a conclusion. And so through that lens, we should walk through the factors and the sub-factors that you have already reviewed, and we'll want to make a finding at the end as to whether you find ultimately that they have all been met and are supported by the weight of the evidence. So again, the umbrella question is whether this a license award to this applicant would benefit the Commonwealth. And in making that decision, you need to look at the following factors. The first is the applicant's experience and expertise related to sports wagering. The sub-factors there in making that decision is to look at the applicant's background in sports wagering, the applicant's experience and licensure in other jurisdictions with sports wagering, and the applicant's proposed sports wagering operation here, or description of the technical features and operation of its sports wagering platform. The next factor is the economic impact and other benefits to the Commonwealth if the applicant is awarded a license, which include the following sub-factors: the employment opportunities within the Commonwealth, the projected revenue from wagering operations and tax revenue to the Commonwealth, and any community engagement. The third factor is the applicant's proposed measures related to responsible gaming, and those sub-factors include the applicant's responsible gaming policies, the applicant's advertising and promotional plans, and the applicant's history of demonstrated commitment to responsible gaming. The next factor relates to the applicant's willingness to foster racial, ethnic, and gender diversity, equity, and inclusion, including within the applicant's workforce, through the applicant's supplier spend, and in the applicant's corporate structure. Next is the technology that the applicant intends to use in its operation, including its geofencing plan, its know your customer measures, and technological expertise and reliability. The next one is the suitability of the applicant and its qualifiers, and I'll talk a little bit more about this momentarily. The sub-factors here include whether the applicant can be or has been determined suitable in accordance with 205 CMR 215, the applicants and all parties and interest to the licensee's integrity, honesty, and good character and reputation, the applicant's financial stability, integrity, and background, the applicant's business practices and business ability to establish and maintain a successful sports wagering operation, the applicant's history of compliance with gaming or sports wagering licensing requirements in other jurisdictions, and whether the applicant is a defendant in litigation involving its business practices. And finally, any other appropriate factor in the Commission's discretion. So that is the standard and all of the factors and sub-factors that the Commission has to take into account as it works its way through this evaluation. The other area that I wanted to draw your attention to as you're working through those sub-factors relates to suitability. And as we've discussed, suitability is described in greater detail in section 215 of the Commission's regulations. You'll recall that there are two types of suitability that are provided for. The first is what was referred to as the durable finding of suitability, which is essentially the final suitability decision. And you'll recall that in order to award a durable finding of suitability, the Commission would have to conclude that this applicant and each of its qualifiers demonstrated their suitability by clear and convincing proof at an adjudicatory proceeding. I would submit to you in this case that has not happened, in which case they would be eligible not for the durable finding of suitability at this juncture, but instead for the preliminary finding of suitability, which is also discussed in section 215. In order to be awarded that preliminary finding, the Commission need only find that there is substantial evidence in the record to support that conclusion, as opposed to the clear and convincing evidence required for the durable finding. So those are all of the factors. You'll recall, of course, as well, that there are a number of conditions that would attach to any such award. And conditions are discussed in section 220 of the Commission's regulations. There are a series of, we'll call automatic conditions that attach to the award of any license, and I'll walk through those. But the Commission should also establish what, if any, other conditions, aside from these automatic ones, that will be attached to the award of any license to this particular applicant. The Commission just talked about one of them, and that is that they vote to adopt the responsible gaming plan by the entity's board of directors be taken prior to the commencement of operations here in the Commonwealth. So that it would be one condition that would attach. The commission should discuss whether there are others. You'll recall there were a series of issues and matters that the applicant was asked to supplement. And in fact, it did provide supplemental information on. So I don't believe that there are conditions associated with those. But before we get into any additional conditions, allow me to just walk through the other automatic conditions, just so they're front of mind. And these are discussed in section 220.01. They include the following: that the operator obtain an operation certificate before conducting any sports wagering in the Commonwealth, that the operator comply with all terms and conditions of its license and operation certificate, that the operator comply with Chapter 23N and all rules and regulations of the commission, that the operator make all required payments to the commission in a timely manner. And the first one that comes to mind here, if the commission were so inclined, would be a requirement that the applicant pay the $1 million fee for a temporary license, that the operator maintain its suitability to hold a sports wagering license, and that the operator conducts sports wagering in accordance with its approved system of internal controls, consistent with 205 CMR, and in accordance with its approved house rules, in accordance with Chapter 23N Section 10A, and consistent with 205 CMR. So those are the automatic conditions that attach to any license. So Madam Chair and Commissioners, before you move into the final review, I just wanted to check to make sure there are no additional conditions that a commissioner would like to see included in the award of any license.
Commissioner O'Brien did just mention the RG draft plan, and would like, if we could give the latitude to the applicant, Commissioner O'Brien, upon launching that they've adopted. I think really your point, right?
Yeah, I think the language I would ask for is that as a condition that that Fanatics license, if they're a licensee, have a board approved responsible gaming plan prior to any launch in the Commonwealth of Massachusetts, and that they provide that to the commission, either through IEB or to the commission directly.
Can I tell you my level of discomfort on this? It's not high, but we didn't ask the others to have their drafts adopted. Now, they had something prior, but we didn't really look at what they had prior. We only looked at what their drafts. I do feel we're treating this applicant a little bit differently, but it's.
I don't, Madam Chair, because everyone else came in and stated as part of their applications and presentations that they had an official RG plan or policy that is completely absent with this applicant. Right. And they have presented a substantive draft. They amended it to reflect Massachusetts more depth in the follow-up meetings, and they've indicated that they intend to move on that formally. So I'm not looking to get a formal Massachusetts-based plan, et cetera. I want to know that the company at the corporate level has an RG.
Just that it has an RG. And,
yes.
And that's fair. And I must say they've been very responsive, and we have received an RG plan as well as the information around training, and it's excellent. So we appreciate that, right? I see Mr. Berger.
Yes, if we may, just one perhaps clarification on the approval process. Because of our governance structure and the way we approve plans in the normal course, our gaming related plans are actually approved by our compliance committee in the normal course. When we talk about approval, we'd be talking about the compliance committee who has delegated authority, through the company. So we just wanted to be clear that it's not going to be a per se board approval, but rather a compliance committee approval. But that's considered to us an official approval of the plan.
Right. So just consistent with your internal operating procedures. That's all I'm looking for.
Okay. Yeah. We just want to be careful to condition to say board per se, but. Yeah.
And Commissioner Maynard, I think you were trying to weigh in.
Oh, I saw Mr. Berger was off mute, but I also have a follow-up question. Do you not have any RG plans adopted in any other jurisdictions or anywhere related to sports wagering, Mr. Berger?
I'll let Alex, I don't know if you want to weigh in here. We are in the process of approving all of our plans as we get ready to launch. Alex, I don't know if there's
Correct,
any.
Commissioner. It's always been our intent to have those plans adopted ahead of our launch of a mobile platform. So we've moved it up in this case, just to give it additional comfort that would be there before we launch.
Okay. All right, Madam Chair, like you, I share in some discomfort because honestly, I don't remember who had draft plans in front of us or who had permanent plans in front of us, but the applicant saying that they have no plans in place. So I would join Commissioner O'Brien on that condition. But I do think we need to go back and look at some of the prior decisions we've made.
Okay, I think, I know that they all had plans, but they were different statuses. I think that's my clear memory. I do believe, and you're closer to the application wording than me, Commissioner Mina, but I think it was draft. I think I checked that early on, was acceptable. But I appreciate Commissioner O'Brien's question, and I see that it doesn't present a massive obstacle for you. And I think that Commissioner O'Brien, with the clarification, the language would
Yes.
be that pursuant to their governance procedures, they'll
Right.
be able to
And-
adopt what was presented to us.
Right, and I want to make very clear that this request, it has nothing to do with what I think is their plans or their ability or their intention and their past track record for their, their employees and employers. I don't want to say that at all. In fact, there's a lot about it that I was impressed by. I'm just looking for more formalization of it before launch.
Excellent, thank you. Okay. Any other conditions that we want to attach other than those that are, as Todd said, automatic? Okay, Todd, can you walk us through the next step of this process, please?
Yes, of course. So assuming that all are in agreement that it is the preliminary finding of suitability that's in play and not the durable finding. And just to clarify why that's important, assuming that's the case and the commission ultimately elects to move ahead here, that would make this applicant eligible to apply for a temporary license. And there's a process in place and an application that will make sure gets over to the entity to submit. Assuming that that's all in place, the question now, commissioners, is whether you believe that there is substantial evidence in the record. And by the record, we mean in the application that's been submitted and any testimony and other information provided as part of these proceedings. Whether there is substantial evidence in the record to conclude that awarding a license to this applicant would benefit the Commonwealth, and that each of the factors that I've outlined just previously are also supported by substantial evidence in the record. And if so, you may allow this applicant to move forward in the process.
Mr. Grossman, I think in terms of you saying we're all in agreement, I think
That's fair.
Legal analysis.
Yeah.
Yeah. I think in terms of a legal analysis, the durable suitability isn't really available to this applicant because they haven't been subject yet to an IEB review. Is that correct?
I think it would be fair to say there is no evidence in the record that they qualify for a durable finding of suitability at this juncture, which is standard. That's how every other similarly situated applicant has come in. Just it hasn't happened yet. And just to clarify what that means, it just means that this entity, like every other that has gone through this process, would now go through a thorough, comprehensive background check. And the matter would be brought back before the commission at an adjudicatory proceeding to determine whether there's clear and convincing evidence of its suitability. And that's why a temporary license is awarded at this juncture, while that is all going on in the background.
Thank you. Thanks for that clarification. That structure reflects what we understand the legislature and the governor contemplated for standing up sports wagering. So with that, commissioners, would you like to move on a finding with respect to substantial evidence supporting all of those factors that Attorney Grossman has laid out.
I can move.
Okay, thank you.
Okay. I move that the commission find, based on the application and what was discussed before us today, yesterday, January the 11th, as well as last week, that the applicant FGB Enterprises OpCo LLC, doing business as Fanatics, has shown by substantial evidence that they have satisfied the criteria set forth in General Laws Chapter 23N, as well as 205 CMR 218.065, that the license award would benefit the Commonwealth, and further that they have established by substantial evidence their qualification for preliminary suitability in accordance with 205 CMR 215.01 subsection 2 and 218.07 1A, and that this approval be subject to the requirements of 23N and the requirements set forth in 205 CMR 220.01, with the additional condition by Commissioner O'Brien that Fanatics have a board-approved RG plan in accordance with their corporate policies and procedures prior to launch in the Commonwealth. You may want to check my citations, Todd.
So following along as you went, I think you nailed it, but I'll have, I think you're.
The board approval, we would, I think that language, could we
I
just
think
say?
he said consistent with their corporate governance
Corporate
policy.
policies.
Yeah,
Okay, thank you.
and I would second the motion.
Thank you. Any further questions? All right. Commissioner O'Brien,
Aye.
Commissioner Hill. I'm sorry, Commissioner Hill, I didn't hear you. I'm sorry.
Haven't made my vote yet, Madam Chair. Aye.
Oh, thank you, Commissioner Hill. Commissioner Skinner?
Aye.
And Commissioner Maynard?
Aye.
And I vote yes, 5-0. Thank you so much. And thank you for your patience over the course of these several days, and congratulations to you. It's not over, as you've heard. There's many steps ahead before that temporary license can be issued, but we know that you'll be working closely with our excellent team on all of those as you move ahead. And thank you for the many days that stretched over this evaluation. We appreciate your flexibility. Commissioners, anything that you would like to add?
Now, just to reiterate, I appreciate the time that you put into the application to making it specific to Massachusetts, the responsiveness when you came back in terms of what we raised as concerns in the first instance. And then, as I said before, the information in executive session to me was critical. Given your corporate structure and the newness to the industry, that was critical information for me moving forward. And I wish you well. Good luck.
Thank you.
Commissioner Hill?
Congratulations, and we look forward to working with you in the very near future and getting this up and running finally. Congratulations.
Commissioner Skinner? Thank you, Commissioner Hill. Commissioner Skinner?
Congratulations to the applicant on meeting this initial threshold, and good luck in the rest of the process.
And Commissioner Maynard?
Congratulations and good luck.
Thank you.
Okay, thank you. And Mr. King, I'll turn to you.
I just want to thank the commission for their time and their diligence. I thought it was a very productive conversation and really appreciate the opportunity to go through the rest of the process.
Excellent. Thank you. We'll let you all go. Good luck and thank you so much.
Thank you.
Thank you.
Commissioners, before we leave, we'll need a motion to adjourn this public meeting. We'll be meeting again at 10 o'clock on a regular public meeting. So good stretch of work ahead of us today. Commissioners?
Hope to adjourn.
Thank you.
Second.
All right, Commissioner O'Brien,
Aye.
Commissioner Hill,
Aye.
Commissioner Skinner,
Aye.
and Commissioner Maynard.
Aye.
And I vote yes. Thank you again. See you, everyone at